case.
Yes, Your Honor. Yes, Your Honor. Larry Gray is a panel member.
Thank you. And at 2:30, we have People versus Bingham, but those lawyers are not required to be present yet. I'll check to see that they're here at 2:30. As all counsel know, these cases, all of our cases, are streamed and archived. Two of these cases involve sexual assaults. We have experienced counsel here. You're familiar, I take it, with our policies regarding the identification of children and victims. Obviously, be careful what you say, because once you say it, you can't take it back, since it's archived. Each side has 15 minutes. Appellant can reserve any amount of time you wish, but the timekeeping is up to you. If anyone in the gallery has any electronic devices, please turn them off. We're told that merely putting them in airplane mode is not sufficient and may interfere with our recording system. So if you have any such devices, please turn them off. Again, because we have very experienced counsel here, I'm sure you know our protocols, but if you have any questions about the upcoming argument, I invite them now. Mr. Miller? Ms. Ford? Ms. Milani, I'm sorry. Thank you. Let's then proceed with oral argument in the first case. People versus Abraha.
May it please the court, and good afternoon. I'm Norman Mueller. I represent Mr. Abraha. I would like to first address the exclusion, the trial court's erroneous exclusion of the defense expert witness. And I think it's necessary to keep in mind the factual context of this case, in that this was a very close case as to Mr. Abraha. He was acquitted of one count, physically helpless. We have argued in a separate argument that the evidence is insufficient as a matter of law that he caused submission. The third count of which for which he was convicted is the unable to, the victim being incapable. And on that, the evidence was very, very close, because we have video evidence, surveillance videos of both Mr. Abraha and PS in the hotel lobby, basically both somewhat wobbly, but navigating the hotel lobby. Right before they hold hands, PS hugs another member, hugs somebody else in the lobby. TG, I'll use his initials because I cannot pronounce his name correctly, before walking up 3 flights of stairs. So I say that because at the end of the day, I think this court is going to have to conclude whether the error here was harmless beyond a reasonable doubt. We will argue that it is not harmless beyond a reasonable doubt. The trial court made absolutely no findings, and this is a rather unusual case in the sense that there was no pretrial challenge to the qualifications or the opinions of this witness. There was a motion in limine which sought to limit the testimony, which was essentially uncontested, because there were some comments in the expert's report which the defense did not argue that they were going to try and elicit, sort of comments on the on what he had seen in the video, what he had seen in the video evidence.
Mr. Mueller, is there any way for us to figure out whether the jury convicted your client on a principal basis as opposed to complicit basis?
No. And that's one of the problems with this case, is because the district attorneys submitted complicity instructions as to both defendants, as to all counts, except for the co-defendant's count, there was a sexual contact charge for which there was not a complicity instruction. But as to the felony counts, there were complicity instructions going both ways. There was no special verdict. There's no way to know.
Mr. Mueller, does the fact that Mr. Gebre-Yohannes was
Very good
acquitted,
pronunciation, Your Honor.
Thank you, that he was acquitted of the offense of victim incapable of appraising her own conduct, yet Mr. Abraha was not, doesn't that indicate a principal conviction rather than a complicit conviction in that charge?
Well, I think it could on that charge, but the problem here is that you can't tell what the jury did because we don't have any kind of special verdict. And it's true that the prosecution's theory at trial was that Mr. Abraha was a principal and T.G. was a complicitor. Nevertheless, when you see these instructions, there's no way of knowing what the jury did. Now, had I tried this case, there would have been some challenges to the submission of the complicity instructions. But you are correct, Your Honor, that there was that difference in the felony verdicts rendered by the jury.
Mr. Mueller, does the exclusion of Mr. Abraha's proposed expert witness go only to whether he was guilty as a complicitor as opposed to a principal?
Well, I think that's a good question, Your Honor, because there was no doubt that Mr. Abraha acknowledged that he'd had sex with P.S. in this case. And he said she consented. We were both a little drunk. I thought she enjoyed it. I thought she consented. But I think the point here is that you can't make that determination without knowing a lot more. And if you'd have had a special verdict form, that may have helped, or if there had not been complicity instructions. But you have to assume the jury applied complicity as to both defendants. And that's why I don't think we can tell for sure what this jury did.
So does that mean the answer to my question is yes?
Okay, go back to the original question, because I got lost in my own answer, Your Honor.
So I was asking whether the exclusion of Mr. Abraha's expert goes only to the issue of his culpability as a complicitor as opposed to a principal.
Well, here's the problem with that, and I don't think the answer is a straight yes, because both defendants were convicted of causing submission. Both were instructed, the jury was instructed, they both could be found guilty as principals, they both could be found guilty of complicitors. And the evidence on the DNA evidence and why it was so prejudicial to exclude it dealt with a lot of very significant DNA evidence, and perhaps most importantly, the whole issue of secondary transfer. Because, as I also argue, the prosecutor misstated in closing argument, and indeed the expert made some mistakes, but the prosecutor argued, without objection unfortunately by these defense lawyers, that the possibility of secondary transfer was 85% as opposed to 25%, for example. So we know that P.S. was in a car between Mr. Abraha and T.G. We know that she hugged T.G. We know that she was in a motel room. We know that T.G. went into the motel room, used a towel. Presumably she also used a towel. So there were many. Secondary transfer was just one example of the crucial DNA evidence that the defense was left with only one side of this story. That is, the prosecution got to put on their DNA evidence. It's clear these defense lawyers had they barely cross-examined several of the witnesses. They did not cross-examine some of them. They intended to present their DNA evidence in the form of their expert witness. And since there was no pretrial ruling, the additional, the additional prejudicial fact is that this witness was called by the defense. There was references, I believe, in opening statement, and I'm not positive about that. And in front of the jury, the district attorney's voir dire morphed into basically a cross-examination, much of it improper, in terms of, what about this opinion in that case? Didn't you say this in another case? It morphed into to what I would argue was an improper cross-examination. And then without findings and without any explanation by the trial court, the witness is excluded.
Mr. Mueller?
Yes.
If the TG division vacates his sex assault convictions for lack of evidence, where does that leave us?
Well, it leaves us with number one, with a very unfair result. And I would submit, and I understand that there's a separate division, that case has not been assigned to this division. And I think argument is coming up next week. So that is a conundrum, I would say, because again, we have complicity instructions and this division, and I don't believe the other division, can know exactly what the jury ultimately determined, other than, I submit, it's pretty clear that this was a wrongful exclusion of expert testimony, given the broad and liberal intent under the rules of evidence in 702 to allow expert testimony. And in this case, the exclusion of that evidence prevented Mr. Abraha from presenting his defense. That's a denial of due process, and at the end of the day, it denied him a fair trial. And that's why we're asking, and we submit, that the prosecution is not able to sustain their burden, it's on this side of the courtroom, to prove that this error was harmless beyond a reasonable doubt.
This may be just a rewording of Judge Taubman's question, but I want to make sure I understand. If we knew that the jury convicted your client only on the basis of being a principal, okay, would you agree that even if the exclusion of the expert testimony was wrongful, it was harmless?
I think I have a much tougher argument in that case, Your Honor, because there was no doubt that Mr. Abraha admitted to, from the very beginning, from the time he went to the police department, that he had had sex with PS. But he was convicted of a count that that TG was convicted of, and the jury was told they could find both of them guilty as either principals or complicitors. And under these facts, under these jury instructions, and under these verdict forms, there's no way for this court to know. And that's why we are simply asking that Mr. Abraha be given the chance to have a fair trial, the right to present a defense, and that's why his conviction needs to be reversed. I would reserve what time I have left for rebuttal.
Thank you.
May it please the court, Elizabeth Ford Milani, registration number 48843 for the people. This court should affirm the judgment of conviction. The surveillance video in this case tells much of the story, and if I could, I'd like to talk about the high points of that to frame the discussion here. At 2:45 in the morning, Mr. Abraha, wearing a white jacket and hat, entered the motel lobby. 30 seconds later, the co-defendant, wearing a red jacket, walked in with the victim. The check-in process took a few minutes. At 2:48, just a few moments later, Mr. Abraha gestures to the co-defendant, and the co-defendant goes and stands next to the victim, watching over her as she takes almost 4 minutes to write down her name. At 2:52, Mr. Abraha and the victim go upstairs. The co-defendant tries to follow them, but then leaves. Skip forward about 25 minutes. The co-defendant, still wearing the red jacket, returns to the motel lobby, and he goes upstairs. 11 minutes later, Mr. Abraha, this time wearing the red jacket, walks out of the motel. 3 minutes after that, or about 14 minutes since he entered the second time, the co-defendant leaves the motel wearing the white jacket. Once he gets outside in the parking lot, just after a few minutes before Mr. Abraha is even in the camera frame, he takes off the jacket and hat and holds them out, and Mr. Abraha comes and takes them. Abraha then returns to the motel and then leaves. I think in this case, the important point for the expert testimony is this. Mr. Abraha's theory was consent. The DNA expert, Mr. Eikelenboom, would not have rendered any opinion with regard to consent. Nothing about a DNA expert could have given such an opinion. In fact, a prosecution expert said earlier on, That's not our job. Our job is to figure out the who, not the what or the why.
Ms. Milani, what about the complicity instructions that were given to the jury?
Certainly, they obviously could have found in this case that Mr. Abraha was guilty as a compliciter, but there was also sufficient evidence in order to find Mr. Abraha guilty as the principal in this case. And considering that this court can affirm for any basis in the record, there was plenty of evidence in this case, and assuming that the jury did find him guilty as a principal, that was perfectly sound. But we really don't even have to get there, because the trial court did not abuse its broad discretion.
Before you go there, Ms. Maloney, if the other division to whom the TG case is assigned determines that there was insufficient evidence to sustain TG's conviction, where does that leave us in terms of the argument you just made?
With regard to means of sufficient consequence?
Well, with regard to the value, if you will, of the expert testimony that the court excluded.
I still don't think that that would require reversal. First of all, the reply brief is the first time that sets out this important testimony that Mr. Eikelenboom would have given. As I said, none of it relates to consent, but these conclusions also didn't further the co-defendant's theory that he never touched the victim and his DNA ended up there via secondary transfer. To the extent it pertained to secondary transfer, that topic was discussed at length at trial by the prosecution's expert and during cross-examination. So the value of Mr. Eikelenboom's testimony, to the extent it wasn't already covered or it wasn't already cumulative, had nothing to do with consent or with the secondary transfer theory, as they've set it out in the reply brief.
Counsel, is it your position that prohibiting the defense from being able to present such evidence in their words is not, that's not a problem as long as the prosecution gets to say it in their words?
I don't think so, but I think that's sort of melding two different inquiries. One of them is, was it inappropriate to exclude him? The second, was it harmless? And because a lot of this testimony, and because Mr. Eikelenboom's conclusions in his report, and we didn't have an offer of proof at trial, so his conclusions in the report were reflected in the evidence, it's unclear to see how on earth he could have been prejudiced if all this evidence was properly before the jury and argued in closing. The secondary theory, or the secondary transfer theory, was argued. So just based on the record we have before us.
Ms. Milani, in the Shrek case, the Supreme Court said that a trial court judge is supposed to make findings regarding the admissibility of an expert witness, and here the trial court judge made no findings. What is your view about that?
So I don't contest that the findings here were not on the record, but I think based on the lengthy voir dire, it spanned 28 pages or so of the back and forth. I think based on the voir dire and based on the specific objection by the prosecutor, which was, this expert is not qualified, the trial court made an implicit finding that the expert was not qualified.
I'm a little concerned. Frankly, it seemed like the prosecutors sandbagged the defense. They filed that omnibus motion in limine. They tried to limit the scope of the defense expert's testimony, don't say anything about a Shrek challenge, and then at trial spring the Shrek challenge after the prosecution's, I think, 5 different DNA experts had testified. Seems a little unfair, isn't it?
Well, I don't think there's any requirement in order to bring these issues up pretrial. If that were the case, then voir dire would seem to be unnecessary or superfluous in some way if these qualifications could not be explored on voir dire. And I think in this case, the basis was established. The trial court gave the defense counsel not one, but 2 opportunities to come back and to fill the holes that the prosecution exposed, and they simply were not able to do so. So I think that voir dire was the perfectly appropriate means to challenge this particular expert based on his report.
Respond, if you will, to Mr. Mueller's suggestion that this, under the guise of voir dire, was really cross-examination on the credibility of the expert, not on his qualifications.
I think that those are they're part and parcel of each other, I suppose. Credibility can pertain to qualifications because the court sitting there is making this determination as to whether this person is qualified. If he's rendering opinions that are outside the realm of a typical DNA expert, I think that all goes to his qualifications. And what we can look at is, in his report, going to the credibility point, Mr. Eikelenboom opined that the victim could have used the rape allegation as an alibi. Rapists tried to hide evidence, so checking into a video-monitored motel is not something a rapist would normally do. All of these ideas go to his underlying opinions and whether those are he's qualified to make. And the trial court was able to consider all of these facts.
But Ms. Milani, isn't it true that at the motion and limine hearing that the defense counsel agreed to exclude those very statements that you just mentioned?
Yes, but I think that that could still be considered by the court. And why would someone holding out themselves as a DNA expert make these conclusions?
Well, but more than that, I mean, the mere fact that an expert makes or gives unwarranted opinions, I don't really understand why that somehow allows a trial court in a criminal case like this to exclude opinions for which the expert is qualified.
So-
I mean, isn't that, I mean, that would be fodder for cross-examination, and of course, the prosecution would argue, this expert doesn't know what he's talking about, look at these crazy opinions. But that's not the process under 702, as I understand it, to qualify an
Certainly,
expert.
certainly. I think that there's two components here. One are these opinions that are in his report, which clearly have nothing to do with DNA. But as a DNA expert also, this is what was explored during voir dire, Mr. Eikelenboom did not establish his credentials to be an expert in analyzing, in the extraction, and reviewing DNA. And that's really what the trial court, that's what the voir dire was about. Like you said, Judge Taubman, the other opinions, the extraneous opinions, were not discussed because those were excluded before this all occurred. But at bottom, the prosecution exposed the fact that Mr. Eikelenboom was just not qualified to render these opinions.
But in the process of doing that, in the attempt to do that, the voir dire ranged into DNA opinions he had given in other cases, correct?
Yes.
And your suggestion is that a trial court is allowed to assess when determining baseline qualifications under 702. A trial court should be able to entertain lengthy discussion, lengthy inquiry about all of the opinions they've testified to in all other cases?
I think it goes to his qualifications in this case. And in fact, the prosecutor, when talking about those other cases, the prosecutor was using them as a frame of reference to really narrow in what his specific qualifications were here. For instance, the prosecutor would ask questions like, Mr. Eikelenboom, in the David Cam trial, did you say that your experience in the Netherlands was XYZ? And that was sort of how those other cases were used to frame the expertise, context, and discussion. And I think that it was perfectly proper. I don't read either the opening or reply brief taking issue with those sorts of questions more specifically, and I'm not aware of a case that would preclude that sort of questioning. But all of this underlies the fact that when Mr. Eikelenboom worked in the Netherlands, he said, I did not do lab work. I did not do bench work. In fact, there is a certification in the Netherlands for a DNA expert. I didn't have that. Then, once he started his own company in 2005, he started doing this DNA work, but he simply didn't explain how he was trained to do so. Not only that, it was unclear how much of that work he had done. He said that the lab, his current lab, did all of the profile analysis in the Netherlands, but he said that he lived and worked in Conifer. This was not a reasonable explanation of how he could have been able to opine on the veracity and the scientific reliability of the prosecution's DNA analysis.
What's the standard of review that we use to determine whether or not the exclusion of the expert was reversible or error?
So my position is that it's harmless error. This is exclusion of evidence, just like excluding other evidence. Of course, a defendant has the right to put on evidence, but only within limits. So my position is that it's harmlessness. My opponent obviously disagrees and says this raises to the constitutional harmless error. But because all these other topics were explored in other places during the trial, the defendant wasn't denied any means of presenting this evidence. So my position is it doesn't rise to the level of constitutional. The review shouldn't be constitutional harmless error, but even if it is, it's harmless beyond a reasonable doubt.
That's the standard of reversal. What's the standard of review
It's abuse
for
of
error?
discretion.
Okay.
Abuse of discretion, Your Honor. And that's not only abuse of discretion, but abuse of broad discretion. I mean, the discretion in this case for the trial court is very clear that it is broad and wide, and the trial court is the one sitting there listening to the voir dire, interpreting the qualifications as described.
Doesn't the absence of findings, which the trial court's instructed to make under Schreck, make it very difficult for us to determine whether he exercised discretion at all?
I think that the record of the entire voir dire helps make that conclusion, and that it was solely focused on his credentials, qualifications. That is the basis that the prosecutor challenged him under. And later on, when the defense asked the trial court to revisit its findings with regard to the accreditation, the court seemed to reference again that this is a qualifications issue and it just hasn't been established. And I say that, I don't think he specifically said I'm excluding this on the basis of qualifications, but he talked about the qualification of that accreditation. So that was sort of the context.
Ms. Milani, if I'm remembering correctly, you told us a few minutes ago that the extraneous statements that the defense counsel said he was not trying to have admitted were something that the trial court could consider in the overall evaluation of whether Dr. Eikelenboom could be qualified as an expert. Am I remembering that correctly?
If I said, I don't remember, but yes.
Is that your view?
I think that certainly those opinions were before the court, and I say that not necessarily because the court would have read every component of this report, but because those specific opinions were discussed.
Well, to follow up on Judge Tao's question about findings or the lack of findings, wouldn't it have been important to know whether the trial court judge relied on those extraneous statements in determining whether Dr. Eikelenboom should be qualified as an expert?
It would have certainly been helpful, but I think that the voir dire itself, the focus on the expertise, that gives a sufficient basis to support that, I suppose, implicit finding of exclusion. And I just want to talk about the Schneider case for just one brief moment. That is in regard to the merger argument. And I just want to clarify that in the reply brief, my opposing counsel distinguishes that case by talking about that there's two different sexual assaults. That's not the language of Schneider. Schneider talks about a single continuous penetration. So I think that case is really helpful here with regard to merger. And with the remaining time that I have left, I do think that there was sufficient evidence to convict Mr. Abraha as a principal or a complicitor. I think that walking with the victim, isolating her from her friends, leading her up to the motel when she was intoxicated supports the conviction. Thank you.
Thank you, Ms. Maloney. Mr. Mueller, you have 3 minutes and 58 seconds.
Thank you, Your Honor. I think the court's questions highlight the difficulty that this panel has with the fact that no findings were made whatsoever by the trial court, and we don't know why the trial court made its findings. I suggest in the reply brief a reason, and that is we had a trial judge after 5 days, in the 5th day of trial, deciding that he might have to declare a mistrial before the defense put on any witnesses, and that was due to the interpreter's problem that he had, and I detail that in the reply brief. I want to quickly go back to the complicity issue because the Attorney General today and in her briefs argues that there's sufficient evidence to convict Mr. Abraha of both counts, both felony counts, under the complicity theory. And why we can't know, and this court can't know what this jury determined, is because the prosecutors in this case kind of threw everything up against the wall. And one of the things that they implied or suggested to the jury was that perhaps TG didn't just touch PS in the hotel room, because there was some DNA evidence suggesting the possibility of oral contact. The Prosecution argued maybe more went on. In any event, this was a plot between the two, so argued the prosecution, to both sexually assault PS. So we don't know what that jury decided. Did this jury decide based on the video evidence and on Mr. Abraha's testimony, his willingness to come in, his interview just a day or two afterwards, that he had consensual sex? Did they decide that, well, maybe PS consented to sex with Mr. Abraha? After all, they had a conversation. He knew where FTG testifying that they were making out in the car. And so did the jury decide, well, maybe there was, as a principle, there was consent, but Mr. Abraha is guilty as a complicitor because we don't know what TG did in that room, and he facilitated that. That's why the error in this case is prejudicial. And I suggest that this court look at both Golub on the harmless error beyond a reasonable doubt, Justice Hobbs' opinion, and this court's decision in Dunham. Because when you are looking at the exclusion of evidence, that evidence, when it's excluded, it infringes on a jury's deliberative process. And this court, an appellate court, can't calculate what damage was done. And I say Mr. Abraha was denied a fair trial, and he should be given a new one. Thank you.
Thank you. Thank you, counsel, for your excellent arguments. The case is submitted. We will issue a written decision as soon as we can. Counsel are excused. After you've vacated the table, counsel for the next case can set up. Our next case is CSH Property versus Sally. Counsel ready for argument?
Yes.
We'll proceed.
Ready to proceed, Your Honor. This is a case that really surrounds binding authority by our Supreme Court. In this case, there was a default on a loan. There were years and years of, we'll call them attempts to modify the loan. There were more than one foreclosure, ultimately ending in a foreclosure beyond 6 years after the default. The plaintiff filed for eviction, and the defendant alleged that the sale was improper because the statute of limitations had run. It should have been a simple issue. Kirk versus Kitchens from this court, which, by the way, is backed up by the account broker's case, where there was a repossession and a bunch of arguments about whether the repossession was an acceleration. This court in Kirk decided that a foreclosure is an acceleration. Then you move to Lovell versus Goss, which is a 1909 Colorado Supreme Court that clearly and unequivocally says that a acceleration, the statute of limitations, runs from the default leading to the acceleration.
Isn't Kirk open to severe criticism based upon what the Supreme Court said in Hassler?
I think Hassler backs it up. The dissent had criticized in Hassler that the repossession made no difference.
In
But I think-
Hassler, though, there was more than just a foreclosure. Wasn't there a repossession? Wasn't there a letter that was also sent in addition to the act of foreclosure or repossession?
There was a letter like in this one. Now, I don't think it's in the record.
But isn't that a significant distinction such that there's a real question as to whether Kirk remains good law?
That's going to be for you to decide.
Well, yes, but I'm asking for help.
Let me give you mine, okay? We try to consider these in an academic vacuum, but let's look at the real world. In the real world, what happens is they institute a foreclosure, and the homeowner at that point has to fight the foreclosure. He goes out and gets a lawyer. He has to pay money for that. But also, the lender will not accept any payments at all. So he can't make the payments. He continues to get behind as things progress. So the question is, can we imply a foreclosure from an acceleration from the foreclosure? And
But the law that we're bound to apply is there has to be, quote, "a clear, unequivocal affirmative act evidencing the creditor's intention to take advantage of the accelerating provision." And the trial judge said there was no such clear, unequivocal affirmative act, and I take it you claim there is, and you rely solely on the foreclosure itself?
correct, yes.
So
That
if
is.
that's wrong, so if Kirk is no longer good law, then you lose. Is that fair to say?
Let me think about that for a minute. Perhaps, I don't know if there's anything else in the record to support it, but I relied on Kirk. Can I put it that way?
Sure, absolutely.
I might add that I argued a case in another division called Peterson recently, that I'm guessing some of you may have read, where I didn't understand how they were thinking. And when I got back home and got the opinion, they rendered an opinion that a lender could de-accelerate by allowing a person the opportunity to cure all of the past default. So as a practical matter, what you get is, "Dear Mr. Sally, we're giving you another chance. Please send your check for $146,397 by return mail," and you're cured. The problem is, as a practical matter, it puts an end to payments and brings the whole thing forward into the foreclosure.
Mr. Fraser, can I roll the clock back just a little bit? Because I think there's a threshold question that I have.
Okay.
Why do I have jurisdiction? Why do we have jurisdiction over this? Why is this a final and appealable order when the summary judgment was only granted in part and there is remaining, I assume still remaining, the question of how much rent is owed?
It's a question I hadn't thought of.
I assume that still hasn't been resolved?
It may not have. That hits me by surprise. I've got to say that.
It did me as well.
So we may be back. So let me finish my argument, so if I have to come back.
Can I just follow up, though?
Yes.
I mean, isn't it possible to foreclose based upon a default in a single installment payment? In other words, it's not legally impossible to do that, is it?
That's correct. Now, there's a certain foreclosure you have to file. There are two statutes, and there's certain separate notices they have to give that nobody ever does. But you can, yes. It didn't happen here. Clearly did not. And I've never seen it happen in the whole time I've been handling these cases. In fact, it came up in Peterson. We argued that extensively, that there's a separate foreclosure statute for foreclosing on installments. The problem is that the foreclosure puts them behind, and there's no way they can catch up. In Peterson, it came up about some of the other states' remedies that they had to solve this. And in Florida, they allow them to de-accelerate and give the person a new chance to start paying. Then if they don't pay, they can foreclose. The problem that we have here is that they go back and base their foreclosure on this ancient, sometimes, we have a case in the federal district court right now where they went back 10 years and tried to foreclose on the person and allowed them to cure if they wanted to make all 10 years worth of payments.
Mr. Drazek, the Lovell versus Goss case, can you tell me what effect, if any, the enactment of Section 1380-108 sub 4 would have on that? That's the definition of accrual.
I haven't read it.
So, according to statute, which wasn't in existence when Lovell was decided, the accrual of a cause of action for debt occurs, quote, on the date such debt becomes due.
Okay,
The debt becomes due, the accelerated debt isn't due until the acceleration occurs. Wouldn't you agree?
that's correct. Well, no,
So-
because the payment was due when the payment was missed.
So the cause of action accrues for that payment
Yes.
when that
yes,
payment was due.
Yes,
The cause of action for the entirety of the debt does not accrue until the lender chooses to accelerate. Wouldn't you agree?
correct, yes. But in this case, they demanded payment of even the time-barred portion to continue on with the loan.
But it's the foreclosure that leads to the payment, to the debt for the entire amount, or the person owing the entire amount.
For the entire amount, yes.
So wasn't Lovell abrogated by statute?
I hadn't thought of it. That comes as a surprise to me, I've got to admit. It accrues when the payment is due. So the question then you would have is if they foreclose based in part on the time-barred assignment, would it repeal Lovell? That's a good question. I'm sorry, I'm not prepared for that. So I wanted to talk about, one problem that I have is the trial courts don't seem to be following Lovell or giving a reason why not to. If this had come up in the trial court, Your Honor, I'd have had an answer to this. It comes up for the first time today. Because Lovell is the answer to a lot of the problems that we have. I have a case where a federal judge decided he wanted to re-examine Lovell. Well, he can't do that. It's up to the Colorado Supreme Court to re-examine Lovell. What it does is it gives a set date that everyone expects to have happen when the statute of limitations runs.
Mr. Drazek, what is your view about whether the statute of limitations or the accrual of the statute of limitations resumed because of any payments Mr. Sally made after the bankruptcy proceedings were filed?
Statute of frauds prohibits it. That statute is ultimately clear that you can't imply a promise from under any circumstances.
What about his written promise to pay in the bankruptcy plan?
It wasn't a promise. He indicated that he would approve of bankruptcy relief. There's no place that says I acknowledge in there. It
It
says
says he'll make payments directly to the lender in the full amount for 278 months.
as a condition of bankruptcy relief. And we cite a New York case
And that New York case was
Colorado
rejected by Christensen, which you argued in the federal court, correct?
which I did argue in federal court, in front of the same judge who found that our 15-year statute of limitations applies in Abdusky, who decided to reevaluate Lovell versus Goss, even though, without ever mentioning the statute you just brought up, Your Honor. He just decided he would reevaluate it. So I'd like to save the rest of my time for rebuttal.
Thank you.
Good afternoon. Peter Muccio, registration 34026, appearing on behalf of CSH Property One LLC. I have an outline that I want to follow, but I do want to follow up on that last interchange and just jump right in, because the issue that was raised regarding the part payment was addressed in that Christensen versus City Mortgage case, and the court also addressed the issue of whether or not the statute of frauds applies. And the court in that case indicated in footnote 11 that the statute relates to the enforcement of a credit agreement, not the application of a statute of frauds under Colorado law. Here, we have an agreement that is in writing between the parties. So there's no need to even apply a new agreement because there's an agreement in writing between the note and the deed of trust.
But it's a renewal of the agreement. It's the renewal of an agreement that might have become unenforceable due to the lapse of time. Why isn't that covered by the statute of frauds?
Well, it goes back to the part payment doctrine that has been well established in Colorado. And the Christensen case actually goes back and relies upon, it references the Hutchinson versus La Plata case. And then there was another case that was addressed in the original motion for summary judgment, the Vessels case, that the simple act of a payment by a debtor will restart the statute of limitations and has the effect of hitting the reset button on the statute of limitations when there has been a default.
Do those cases post-date the enactment of the portion of the statute of frauds that's at issue here?
Your Honor, I'm not sure off the top of my head when the statute of frauds of 3810-124 went into effect. I don't know the answer to that. So the issue has been well established with partial payments based on the fact that it matches up with the foreclosure statutes. The foreclosure statutes provide for a right to cure. If we were to accept the argument that Mr. Sally's counsel is purporting Lovell and Goss stands for, there would only be a 6-year statute of limitations from any time there was a default. So any time that there was a cure situation when there was a default, that would set up a 6-year window for enforcement of that underlying debt. That certainly is not the intention of the statutes related to foreclosure that give borrowers the opportunity to cure. My point there is that the argument that the statute of limitations would automatically run from a default is a dangerous argument because it would set up a problem. And really, that is not what Lovell and Goss stands for. Lovell and Goss, the case there was an automatic acceleration clause within the note. So that was different from here. In this case, there was a permissive acceleration clause. There had to be an affirmative action.
Doesn't Lovell versus Goss actually acknowledge that it could be read either way and treat it as a permissive one?
I did not take that interpretation from that. I think the court was trying to weigh out what to do with that, but the note itself was almost automatic. The court made the determination that it was the affirmative action to move forward with the enforcement under the initial default of the interest payment that was where they matched up between that choice to match up with the acceleration and the language of the note itself, I think is where the court ruled on that statute of limitations. The other thing that's interesting about the...
I just
Sorry.
want to make sure I understand your argument relating to Lovell versus Goss. Are you claiming that it was legislatively abrogated? I mean, I thought I heard you argue it's a really bad decision, and that may be, but, you know, if it hasn't been abrogated by later law, it is a decision of the Colorado Supreme Court, and we're bound by it. If it was legislatively abrogated, we don't have to follow it.
I think there is legislative support to say that that is no longer the situation. I also think that it is distinguishable from this case based on the language of the underlying notes itself. The other thing that's interesting about Lovell versus Goss is the fact that they did address the issue of a payment afterwards, after there was a default, because there was the underlying foreclosure that was completed, and then there was the lawsuit that took place outside of the statute of limitations. The Supreme Court looked at the argument and dismissed it that said that the payment from the sale of the property would somehow restart the statute of limitations. The Supreme Court said, well, that was not a voluntary payment by the debtor, so since that was a payment from the trustee, that did not have the effect of restarting the statute of limitations. It may have been different had it been a voluntary payment, but it wasn't.
Back for a moment to the implied promise from the partial payments. How does that square with the statutory language in 1381-13 that requires an acknowledgement or promise to be, quote, sufficient to take a case out of the operation of the statute of limitations if it is in writing and signed?
That's an excellent question. And the cases appear to address the issue of partial payments as they split partial payments and acknowledgement into two different categories. So I think that the issue with that would be if there was more of an acknowledgement, that there would have to be this clear acknowledgement, but that the partial payment can equal an acknowledgement, that there's sort of two different mechanisms there that could come into play. The court did raise some interesting questions related to the case of Kirk v. Kitchens and whether or not and how that relates to an acceleration. The Kirk v. Kitchens did not deal with multiple bankruptcies or did not deal with post-default payments. The Kirk court was analyzing the acceleration with regards to a future interest payment and really should not be relied upon to say that acceleration starts at the filing of the foreclosure. Again, that logic would create a problem with every lender. If they were to accept a cure, then they would have to start some sort of a dual tracking to go back to when the original default, because under the Kirk v. Kitchens model, the debt had been accelerated at the time that they initiated the first foreclosure.
Well, that assumes that Lovell v. Goss is still, that's not a Kirk issue, that's a Lovell issue. Is there a fact pattern by which someone might foreclose and in reality,
In reality.
not some obscure idea, is there a fact pattern in which a lender is going to foreclose but not demand full payment or go after the deficiency? Or, in other words, isn't foreclosure really just, okay, we're done, we want all our money?
I don't quite look at it that way, because you can have a foreclosure that is based on something other than non-payment. You could have a foreclosure where a note was being called because the due on transfer sale, the restriction on due on transfer is triggered. So you can have situations that may go outside of just the payment. The foreclosure in our state is also a mechanism that is curable. There's an opportunity for every borrower to cure that deficiency prior to the sale. And it's not a cure of bringing all of the money that is owed under the note. It is getting caught up and hitting that reset button. And that's very important for both borrowers and lenders to have the ability to do that.
But if we accept that the third argument here of de-acceleration or abandonment of the foreclosure, then it doesn't change the underlying question of, was the act of foreclosure an act of acceleration?
So, and that goes back to the issue in Kirk, which I think is problematic, because you've got to look at what happens with the foreclosure. Just the initiating the foreclosure, or is it the actual completion of the foreclosure? If we go back and we look at the recent issue in the Hassler case, where we're talking about, it wasn't a foreclosure, but it was talking about the repossession of a vehicle. The problem there was the vehicle was actually repossessed. And then you have that acceleration in combination with, I believe there was notice given from the lender in that case. So the foreclosure itself, just initiating the foreclosure, it's still curable, it's still fixable. The parties can still continue on with their underlying agreement and their underlying relationship without having to create a new writing. And that comes from the statutory rights to cure, that are given to debtors and the ability to cure those delinquent payments. The trial court in this case properly relied on the Castle Rock Bank case. And they followed the logic that another division of this court set forth in that case. I do urge the court to consider the issue of the partial payments as well, because I think that is an important factor in this case, where you have a situation where there was multiple payments made to the debtor's lender in order to attempt to save the relationship, in order to continue on with the relationship. They filed bankruptcy. They said, hey, we've got a default and we're going to continue to make payments. They did make payments. That was reflected in the motion for relief that the creditor had filed. Again,
Here's one of my concerns about the partial payment doctrine. The general rule of contract is consideration cannot be found in something you were already obligated to do, right?
okay.
So where's the consideration to support the new agreement?
The consideration would be backing off of pursuing the default. And the lender doesn't have the option to just simply refuse under the state's foreclosure when somebody intends to cure. So the consideration there is that they're not exercising their right from that initial breach that led to the foreclosure being filed.
And what about consideration from the borrower's side? If all he's doing is agreeing to pay what he already owes, or not even agreeing, he's not entering into a new agreement. If we have a new written agreement, we have that other argument. We're talking about just partial payment. If all the borrower is doing is paying what he's already obligated to pay, and not even all of that, how can one infer a new agreement from doing something that one is already obligated to do?
Well, the borrower is still getting the benefit of being able to own the property. That's the consideration too, is that they're still able to live in the property and enjoy the benefit of that by having the cure. I like to think of it as hitting the reset, because that's essentially what it is doing. You're going back to that original agreement unless there's some new writing to modify the underlying mortgage. If there are no other questions,
Thank you.
thank you.
Mr. Dresik, you have 3 minutes and 55 seconds.
Thank you, Your Honor. I would like to begin by addressing Judge Toe and his statutory theory. That hit me quite by surprise, largely because it's not been raised in the trial court in this case. It was not raised by Judge Jackson and Christensen. This is the first time I've heard it. But now that I could sit down, Lovell versus Goss was considered under the common law theory, where statutes of limitations run from the day a payment is due. And that it goes way back before Lovell versus Goss. The question is, did the legislature intend to change Lovell versus Goss, or was it just enacting the same common law theory that Lovell considered? I spent some time, I typed in the word due in Lovell and couldn't find anything that was applicable. And so, but that's my thinking on it, is the legislature was simply enacting what we've always believed the statute of limitations to be, which is that it runs from the time it's due. So the Supreme Court was saying, in these cases, we're going to engage in perhaps the fiction that it was due from the default.
Mr. Dresik, in Hassler, which is a Supreme Court case, which we are bound by,
You are.
the court says that you have to have a clear, unequivocal affirmative act evidencing the creditor's intention to take advantage of the accelerating provision. Then, in analyzing whether there was such a clear, unequivocal act, here's what the Supreme Court said. We hold as a matter of law that Neurolarco's repossession of the vehicle, coupled with this demand for full payment, left no doubt as to Neurolarco's intention and apprised Hasler of the fact that there was an acceleration. I mean, the court could have said that the repossession by itself, which I take it is similar to the foreclosure of real property, was such an act, but they didn't.
Correct.
And that's why I'm concerned that Kirk is no longer good law.
Let me alleviate your concerns.
Please.
Because in foreclosures, if you look at the foreclosure statutes, there are two statutes. The statute they used here and in every case is for foreclosure with acceleration. So by filing this type of foreclosure, they are accelerating. Now, they can foreclose under Colorado law for past due installments, in which event they must follow another statute, and it's in the briefs in Peterson, I believe, another statute which gives the borrower certain other warnings. So by filing under this type of foreclosure, they can't, then the foreclosure was wrongful. If they didn't accelerate, then it was a wrongful foreclosure. So that's why I think Kirk is still good law. I hadn't thought of that till you asked the question. I had to think for a minute. But
Can you clarify for me one of your arguments? As I'm reading it, I want to make sure I understand it, that the statement in the bankruptcy plan should not be seen as a new promise to pay because that's what he needed to say to get his bankruptcy stay. Is that correct? Or to maintain the bankruptcy stay?
That's correct. And and along the lines of that question, the appellee stated that the consideration is backing off from pursuing the default. Nobody backed off in this case. They pursued the default relentlessly, to the point of sending back payments when he was late in the bankruptcy.
Thank you. Your time has expired, Mr. Gresick. The case is submitted. The court will issue a written decision as soon as we can. Recess? Ted? We're not going to take a recess. Counselor excused. Thank you again for your excellent arguments, and we'll hear argument in our 2:30 case as soon as the lawyers for that case have had a chance to set up. This case is People versus Bingham. I take it counselor present and ready for argument?
Yes, Your Honor.
Yes, Your Honor. You can proceed then.
Good afternoon. May it please the court. My name is Matthew Fredrickson, registration number 47453, and I represent appellant Dr. Michael Bingham. The court imposed an unauthorized sentence on Dr. Bingham. The court aggravated his sentence in a way that was inconsistent with the statutory scheme and for which it did not have jurisdiction to do. This court should remand to the district court for resentencing and instructions on what factors to consider.
How does this case different than Collier, which says that a Blakely challenge is a 35C challenge, not a 35A challenge?
Because specifically of Lopez v. People, which was heard in 2005, which codified the Blakely requirements. Yes, Blakely and Apprendi are at first blush constitutional, but because of Lopez, it was codified to be read into what the discretionary aggravation statutes require. And specifically, that was what Justice Hobbs was dealing with, was how do we maintain these discretionary aggravation statutes. It was 18.1.5 or 18.1.105 at the time of Dr. Bingham's sentence. It's 18.1.3.401 now. How do we maintain that statute when it can be Blakely non-compliant? And they said, well, you can read it as if it were Blakely compliant, and that way it survives. So it is a statutory claim under Lopez v. People and its dealings with Blakely and Apprendi.
So you're saying that the Court of Appeals decisions that hold that a Blakely challenge is a 35C have been abrogated by Lopez?
Not specifically abrogated by Lopez, but it codifies the Blakely-Apprendi requirements and reads them into the discretionary aggravation statute. And that's why 35A can apply, and why specifically Dr. Bingham's sentence runs afoul of a statutory scheme, is because the statutory scheme has adopted the Apprendi-Blakely confines. So because 35A does apply, Dr. Bingham's motion can be considered at any time. And 35A from 2006 with Wenzinger up to 2017 with Wiseman has been defined as that sentence which is either inconsistent with the statutory scheme or which was imposed in excess of the court's subject matter jurisdiction, even if the statute contemplates that range. Dr. Bingham's sentence here fails both fronts of the definition. I start with how the court originally used 18-1-1056. That was what the court relied upon when sentencing Dr. Bingham in November of 2001. It looked at the discretionary elements that caused it to jump to that 16 to 48 range, which is the aggravated range for someone charged with and convicted of an F2, a sex assault causing serious bodily injury.
Mr. Frederickson, how does your argument square with cases that say that if there's one Blakely exempt or Blakely compliant requirement, that is sufficient?
I would answer in twofold, Your Honor. One, not on this record, there are no Blakely compliant factors that the court can rely upon. And two, there is also a process here that requires the court by statute to put its reasoning for aggravating a person on the record, and there were not Blakely compliant factors or Blakely exempt factors found on this record for the court to reach that stage.
Well, I thought the people said in their brief that Mr. Bingham had several prior felonies that could be considered for issuing an aggravated range sentence.
And, Your Honor, none of those were found by a preponderance of the evidence. There was no process afforded to Dr. Bingham to essentially prove those by the quanta of evidence that's required. So there would not only be a failure to prove those by a preponderance of the evidence which he is entitled to, but also the lack of process that Dr. Bingham would have been entitled to have those be found to properly aggravate him.
So to the extent that's a due process claim, that would be a 35C, correct?
Well, Your Honor, for the extent that Blakely and Apprendi elements are read into
That's not
the
my
proper
question. My
aggravation.
question is to the extent it's a due process claim, it's constitutional in 35C, correct?
Yes, if it was solely a due process claim, that would be 35C.
To the extent is a process claim, they didn't take the right steps, that's a manner challenge under 35A, correct?
Well, and that's why we're here today, is to really flesh out what the 35A rule means for an unauthorized sentence. It's not a black and white final articulation of the sentence. There is also this review of whether or not it complies with the statutory scheme and how you properly get to that space, and whether or not there was jurisdiction to enter that space to impose that sentence. So it's not
And that's
a
the
black and
concern
white.
I have. You keep talking about jurisdiction to enter. Jurisdiction is different than authority, correct?
Yes.
Jurisdiction just means that defendant was properly charged and before me as a trial judge, is it not?
Well, Your Honor, I would, marrying the language of the rule which talks about an authorization to act and the jurisdiction to act, I don't think the court has jurisdiction to impose on someone a sentence that's restraining their liberty without given the proper pieces, which is a jury verdict and finding, or the other Blakely-Apprendi elements.
But the jurisdiction to enter the aggravated range sentence, there's no dispute that on the right process, for example, these prior felony convictions, it could have been done, right?
Yes, but that was not afforded to Dr.
So this
Bingham.
isn't a jurisdictional claim, it's an authority claim.
I would submit to the court that the court did not have jurisdiction to impose so many number of years on him because the proper elements were not in place to begin with.
Lopez was decided 14 years ago. Is there a single case in those 14 years that even suggests that your theory about, as I understand it, codifying the constitutional requirements of Blakely and Apprendi into Colorado law now turns it into a 35A? Has a single case either accepted that, addressed that argument in any way?
Not to my knowledge, actually, Your Honor, about whether or not 35A can deal with Apprendi and Blakely because Lopez codified those, are essentially read into the statute, those confines. No. So this court would be doing something of first impression. With that, I would turn to what happened in this case was an 18-1-105-6 reliance. The court pointed to specifically the injuries that the court saw the victim suffering, but that wasn't found by a jury beyond a reasonable doubt. Also, the court looked at Dr. Bingham's remorse, which is something that under People v. Young, the court couldn't consider. And last, it looked at his prior cases, but those also weren't proven by a preponderance of the evidence. So the court overreached what it could essentially look at under the codification of Blakely and Apprendi to reach that range of aggravation to impose this sentence on Dr. Bingham. But then turning from the specific statute relied upon by the trial court, we also look at the statutory scheme as a whole. And we see under 18-1-105 subsections 9 and 9.5 another way to aggravate him. And I draw this illusion, or I draw this kind of illustration, so the court can see that the statutory scheme also does not permit this kind of aggravation of Dr. Bingham's sentence because he was not separately charged with and convicted of a crime of violence on the first 3 charges. We do know that on count 4 it was a per se crime of violence, that second-degree assault 18-2-203, I believe it is, subsection 1G, which is the source of the 4th charge, 18-3-203, I apologize, but specifically 18-3402 subsection 5, where he suffered the most severe conviction, 18-3-402 subsection 5. Subsection B, under that subsection 5, specifically says that it is not a crime of violence. And so 16-11-309 subsections 4 and 5, that's the crime of violence statute, would require a separate charging and conviction for that aggravation. And so I draw that allusion to point to the fact that the statutory scheme would not allow for Dr. Bingham's sentence to be aggravated either, because it was not separately charged and convicted as a crime of violence. So there, in the first instance, it is inconsistent with the statutory scheme and how 35A has come to define those sentences that are not authorized by statute. The next is this ongoing struggle, which Judge Tao, you have drawn attention to, which is jurisdiction. And I would submit to this court that the court only has jurisdiction to restrain someone's liberty after the jury has given them the permission or there's a Blakely compliant factor that allows them to reach that stage. I do think that is jurisdictional. The court does not have that power to enter that sentence. So it would be in excess of their jurisdiction to impose in the 16 to 48 realm on non-Blakely compliant factors or not without a Blakely exempt factor. And so without that crime of violence, without that specific SBI or serious bodily injury being found, without the jury making these certain findings, the court couldn't enter or did not have jurisdiction to enter that aggravation range.
Do you agree that if we disagree with you on any of these points, that as Judge Taubman said, if there's one basis to aggravate, you're done?
No, Your Honor, I would not submit that we are done. I would submit to the court what I would say in my reply brief where I talk about Hoover and Fisk, which says that the process is important. What the court relied upon to aggravate Dr. Bingham is not proper. So even if this court finds one, it still needs to remand for resentencing and the application of a proper Blakely compliant factor. So this court would need to remand with instruction on what could be those Blakely compliant factors and allow Dr. Bingham the ability to go to resentencing and present that mitigation. So with that, I would ask that this court remand for resentencing with instruction on the proper Blakely compliant factors it could rely upon and give Dr. Bingham that sentence, and also instruct that it cannot aggravate Dr. Bingham based on this record, as well as the other 2 issues that I raised in my brief. I'll reserve the remainder of my time for rebuttal.
Thank you.
Good afternoon. May it please the court, my name is Melissa Allen, registration number 23155, and I'm here on behalf of the people. I would welcome any questions that this court might have, but I thought I might jump into what in the people's position are an extraordinary number of Blakely compliant sentencing factors that the court did in fact rely on in this case, if the court even gets to the point of looking at those. And the only transcript that
You
was...
contend we shouldn't even get there? I take it,
That's correct.
because it's time barred?
It's time barred. It's successive. The second argument is successive. It's exactly the same argument that was raised and denied on direct appeal. But the only transcript that is part of the record, so it's very short as far as looking at it, is the sentencing hearing in this case. And the court specifically, well, first, I might point out that the defense attorney admitted that the defendant had to be sentenced in the aggravated range because he was on escape at the time that he committed this offense. So that's the first one. And then he acknowledged that he had multiple felony convictions, which the court also relied on. The court did not just discuss the horrible injuries that the victim suffered. And this is also important. I completely disagree that the jury didn't make specific findings with respect to the aggravation on the sex assault as far as it being a crime of violence. In the court record at pages 161 and 162, the jury specifically found that the defendant caused submission of the victim through the actual application of physical force or violence, and specifically found that as to the sex assault, not just the regular assault, but as to the sex assault, that the victim suffered serious bodily injury. So those were found by the jury beyond a reasonable doubt. So we've got the escape status, the multiple prior felonies, the crime of violence findings by the jury beyond a reasonable doubt. I mean,
Were
there's no-
were those elements of the crimes themselves that the jury found?
No, those were separate interrogatories based on the aggravating part of the statute that increases the felony, so kind of the sentence enhancer portion of the statute. I don't really have much more with respect to the other arguments that were raised, but I will happily answer questions.
Well, I'd love to hear you respond to this theory that somehow Lopez codifies Apprendi Blakely. Not sure I totally understand it, but it codifies Apprendi Blakely and therefore turns what used to be a 35C into a 35A.
I have to be honest, I don't quite understand it either, but I do know that Collier came out a year after Lopez, and it's still good law, so I would disagree, because we've got case law that comes out after Lopez that says it's a 35C. But regardless, however you want to, or however we want to call it, we still have a sentencing hearing transcript and jury verdicts that very clearly delineate that this is a legal sentence, no matter how we look at it. And unless this court has any other questions, I would ask that you affirm the defendant's sentence. Thank you.
Thank you. Mr. Frederickson, you have 4 minutes and 35 seconds.
Thank you, Your Honor. I'd begin by noting that the two interrogatories that the Attorney General cites to were specific elements of those crimes, the F2 and the F3 under 18.3 402 subsections 4 and 5. So those were elements of those specific sex assaults that brought them up to the F2 and F3 level. So they were
So can an element also be an aggravator?
not if it's within its own crime, Your Honor. We do have Montjoy that recently came down from the Supreme Court, which holds on a different issue. But within the specific crime, no, the element can't be used to also aggravate him. And that's specifically from Blakely and the interpretation of Blakely. But I do want to come back to Lopez, because it seems like that is a sticking point. And I do think that Justice Hobbs grappling with how do we make sure that the Colorado statutory scheme is constitutional post-Apprendi and Blakely is important, because they don't strike down the discretionary aggravation. They instead say, because the statute can be interpreted in a way that is constitutional, that's how we will interpret the statute, and that's how the statute will survive. And that's why Lopez has codified, read into the statute, the Apprendi-Blakely limitations, and what makes this a 35A claim, not a 35C claim. I would next draw the court's attention to the Attorney General's mention that I admit the escape status. I don't recall ever admitting anything that he had previously been sentenced on or served or what his status was. My recollection is talking about the fact that that was never proven by a preponderance of the evidence, and that's what's required for it to be a sentencing factor that is not an Apprendi-Blakely claim.
Mr. Frederickson, isn't it sufficient if defense counsel admits either prior convictions or escape status of the defendant, even if they haven't been proven by a preponderance of the evidence?
The question there would be whether or not Dr. Bingham himself stipulated to that aggravated fact or allowed the court to find it on their own volition. Those would be the other two Apprendi-Blakely compliant factors, is stipulation to that. And I don't believe that we have that on the record here, any kind of admission to an aggravated fact.
Well,
So the fact that, say, the pre-sentence investigation report says he has several prior felonies and he's on escape status, and the defendant standing in court does not say, I want to fix that, that's wrong, that's not sufficient?
I do believe he's entitled to process for the court to look at that and whether or not that is proven by a preponderance of the evidence.
Why isn't that a preponderance of the evidence? Why isn't it more likely than not? If he's standing there reading that report and he doesn't say, this is wrong, or his attorney doesn't say, Your Honor, we need to correct the PSI, why doesn't the trial court have a preponderance of the evidence that he's on escape status?
Because unlike the habitual criminal trials where the person gets to go in and actually question the witness on the stand to be able to prove these prior crimes, he's not getting that right. He is he's already been convicted. He's standing there at sentencing. It's a foregone conclusion. It's just all happening in front of him. I don't think that asking him at that stage to interrupt the proceedings and ask for a procedure is a nurse to his detriment. I do think that he would be entitled then to the more formal process that we're seeing in habitual criminal cases.
But the statute doesn't provide that, does it? Except in habitual crimes.
Well, and as we read Apprendi-Blakely and that those prior convictions, and as we look at Peg in the case that I cite specifically to, those factors that are being used against the defendant need to be proven by a preponderance of the evidence, and there should be more than a kind of an inferred finding of those things by preponderance of the evidence, which is what I think you're suggesting, and so I would disagree with that. I also want to talk to the successiveness as my final piece here. Under Talbert, the case I cite to in the reply brief, 35A claims are not successive. The proper way to look at them is under the law of the case doctrine, which is a much more flexible doctrine. And because of what happened while Dr. Bingham's case had still yet to enter a final judgment stage, then this court can look at Apprendi-Blakely and that justification as kind of a changing in circumstances for the law of the case. I cite to that specifically because Apprendi predated Dr. Bingham's case. Blakely came down on June 24th, 2004, when Dr. Bingham's mandate entered June 28th, 2004. So it is still a good law for him. And with that, I'd ask the court remand. Thank you.
Thank you. The case is submitted. We'll issue a written opinion as soon as we can. That completes our docket for this afternoon, and the court will be in recess. The bailiff will please announce.